All rise. Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. This is the time set for argument in our number CV17-41, Nelson versus Allen. Each side will have 20 minutes in which to argue its position. Appellant may reserve a portion of that time for rebuttal argument. Counsel, you need to keep track of that time for yourself. We've conferenced this case. We've read the briefs and are familiar with the facts and the issues presented. Would each of you, as you begin your argument, identify yourself and the party you represent? Counsel for Appellant may proceed.
Good morning, Your Honors. My name is Colleen Thomas, and I represent the appellant, Robert Thomas Kyle Nelson, who is present and seated at counsel table. I intend to reserve 5 minutes for rebuttal, and I'll watch my time. May it please the court. The trial court erred in holding that any disturbance of a plaintiff's possession of property causes the statute of limitations to accrue on that plaintiff's quiet title action. The trial court based its ruling on this court's holding in Cook v. Town of Pinetop Lakeside, where the court held a quiet title action does not seek damages and does not accrue for statute of limitations purposes at least as long as the owner maintains undisturbed possession of the disputed property. Cook did not actually define what a disturbance is or address who would have to cause the disturbance to cause the statute of limitations to run. In fact, disturbance is not used, and the word disturbance is not used in the cases that are cited by Cook that recognize this exception to the statute of limitations, because that's what it is, a common law exception to the statute of limitations for what is called a true quiet title action. That being a quiet title action brought by someone in actual possession of the property under a claim of ownership. Now, the case...
The road or the piece of land that we're talking about was never in possession of your client, was it? I mean, it was exempted from the deed.
Your Honor, it was exempted from the deed. However, Mr. Nelson and his predecessors in interest had been in actual possession of the property.
Well, it was exempted from their deeds as well, wasn't it?
Your Honor, it was. However, in 1962, the town of Paradise Valley passed a resolution abandoning the property to Mr. Nelson's predecessor in interest.
But there was no deed accompanying that resolution.
That is correct. And in fact, in Cook, it's not clear that there was even a deed accompanying the resolution that abandoned the property to him. And in fact, there was a subsequent resolution rescinding the abandonment, yet the court still found that Cook was in actual possession of the property under claim of ownership.
What do the assessor's records show as to the property?
The assessor's records show that it is a town property.
So your client never paid tax on this property that he claims to own?
That is correct. He has never paid taxes. However, the town has never maintained the property. And Mr. Nelson and his predecessors in interest have been in actual possession since 1956. And in fact, this property was originally private property. In 1956, the Beemans, the original owners of the property, subdivided it into 2 smaller parcels. It was at that time that they quitclaimed deed the driveway, that's the property in question, to then Maricopa County. Now, the town of Paradise Valley has succeeded to ownership, but when the town passed the resolution abandoning the driveway in 1962, it acknowledged that this particular piece of property had never been and would never be used as a right-of-way. And it's obvious to see why if we think about the facts alleged in the complaint. This driveway leads to Mr. Nelson's property and in fact provides the only means of ingress and egress to his property. Until 2008, no other property could be accessed by this particular driveway. So the property was never to be used as a right-of-way.
So it was just free property to benefit that land without paying taxes, without a deed, just a gift from the government.
The government abandoned the property. Now, why they never
You
started...
have a constitutional gift clause in this state. The government can't just give people property.
Your Honor, Mr. Nelson and his predecessors in interest would have paid taxes. There was never no taxes were ever assessed on their property.
Well, I know, but I guess the reason I asked the question is to see whether there was any evidence of ownership. I think if no taxes were assessed on the property, that might reflect a governmental view that the property wasn't privately held.
Well, Your Honor, there was indicia of private ownership. In addition to the reasons we've just discussed, that the town actually acknowledged that it would never be used as a right-of-way and that it provided the only means of ingress and egress to the property from Mr. Nelson's property. The other indicia here are that there was a private drive sign posted at the entrance to the driveway since at least 1989. Mr. Nelson's mailbox and his predecessors in interest mailbox had also been located at the entrance to the driveway since 1989.
But that would be evidence that you would use in an adverse possession claim, and that can't run against the town.
Your Honor, the town passed a resolution abandoning the property. So the theory underlying this case, which is not at issue on appeal, is that, if we're talking about the merits of the case, that there was a resolution abandoning the property.
I've had this come up in a recent case. What does abandoning property mean? How does one abandon property? Who owns it if you abandon it?
Well, it was abandoned to Mr. Nelson's predecessor in interest, Mr. McMahon, and his wife. They owned the property at the time. So it was abandoned to them, just like the property was abandoned to Mr. Cook in of course, the case that leads right up to...
And ever recorded?
The abandonment was recorded. In fact, it absolutely was recorded in this case. And what is different from this case than Cook is that there was no subsequent resolution rescinding the abandonment. So if we're talking about clouds on title, and Cook said that at most that resolution rescinding the abandonment was a cloud on title, we have even less of a cloud on title in this case, if we even want to call it that.
I've never heard of an in personam abandonment, though. I mean, if presumably if this is going to come out in your favor, the abandonment would have to be appurtenant to some parcel. But if the town abandons property to me, and I don't live in Paradise Valley, who gets that property that they abandoned to me when I die?
Well, Your Honor, if we take the theory farther, and again, we're not arguing the merits of Mr. Nelson's quiet title claim here. That's not the issue on appeal. But there is an adverse possession claim by Mr. Nelson's predecessor in interest, Mr. Skelton, that he adversely possessed the property from the McMahons.
As against whom?
The McMahons had acquired it from the resolution abandoning the property that was passed by the town in 1962. Then Mr. Skelton, who is a subsequent owner to the McMahons, adversely possessed it from the McMahons as private property owners, and Mr. Skelton has quit claim to the property to Mr. Nelson, who is here today. In Cook, if we go back to Cook, the court found that even a resolution rescinding the abandonment is no more than a cloud on title. And Cook was in actual possession of the property. The court found that was the case, and it was a true quiet title action. Why? Because notice of an adverse interest in property is not enough to cause any damage, and a damage is necessary for the statute of limitations to start to accrue. The court in Cook recognized that the accrual rule applies in an action for damages. Mr. Nelson's quiet title claim against the town does not seek any damages.
On a different point, why was the claim dismissed without prejudice?
It was dismissed without prejudice to then send a letter to preserve attorney's fees under the quiet title statute.
So the thought was, by dismissing it with prejudice and then sending the letter and then reinstituting the case, the right to fees could be resurrected.
Dismissing it without prejudice.
Right, I'm sorry,
yes.
without prejudice, yeah. So sort of a way of curing a procedural default.
Well, a default in the sense that attorney's fees would not be available, and it was
A procedural slip, maybe, is a better word.
to correct, yes, semantics, whatever we want to call it. It was done in order to preserve the right to obtain attorney's fees under the theory that this is a pure quiet title action and no statute of limitations had begun to accrue. Now, the definition of disturbance, again, that term came from Cook, but the cases that Cook cites to are...
Get back to the true quiet title. Isn't that only brought pursuant to a claim of ownership under existing title? And I think we've talked that your client didn't have title to this strip of land.
Your Honor, the case law refers to a cloud on title or existing title as one who is in possession of property under a claim of ownership. The Cook court found, again, actual title or actual possession and a cloud on title. Therefore, there must have been existing title, even though it's not clear that Cook had legal title to property. In fact, it must not have been the case. There was a resolution that was recorded that rescinded the abandonment of the property. Moreover, the Utah Supreme Court has addressed this very issue and reversed the Court of Appeals. The Court of Appeals had held that legal title was required, and the Supreme Court reversed. This is in the Bangerter case, and found that a true quiet title action is brought by one in actual possession under claim of ownership. So legal title is not required. Now, one of the public policies underlying this exception is that we don't want the statute of limitations to work a forfeiture of property rights by the person who has the best claim to ownership, the one who is in possession of property. And in fact, these cases that Cook cites to...
Isn't that what adverse possession is? It's a statute of limitations that works a forfeiture.
It does, Your Honor, but...
So we, and I'm not saying that this is that type of case, but our law recognizes as fundamental the idea that a statute of limitations can do just that.
Yes, but I think you hit on the point. This isn't that type of case. In an adverse possession case, the person who's acquiring the ownership is the one in possession. So again, we give some higher right to a plaintiff who is in possession of the property under a claim of ownership. That's what distinguishes this case from cases like Rogers v. Board of Regents. The court recognized that a statute of limitations defense depends on whether or not the plaintiff asserts a possessory interest in the property. And more than just the assertion of a possessory interest as opposed to an easement, as was the case in Rogers, here we have a plaintiff who's not just asserting that possessory interest, he is in actual possession of the property and has been, his predecessors in interest have been since 1956. We have the town saying, this piece of property has never been and will never be used as a right-of-way. It's for Mr. Nelson to access his property. It's for the owners of this particular parcel of land to access their property. The only reason the Allens can access this parcel is because in 2008, the Allens' predecessor in interest installed a gate in a wall to create access to the driveway, and they had to cut down a 40-foot tree in order to do so that would have blocked any access they had to the driveway. And the Allens' use of the driveway is purely for private use. They do not want their service workers to use their front entrance. They have an entrance, a main entrance to their home off of an adjacent street, not Jackrabbit where the driveway is, but off of Casablanca. So they're utilizing Mr. Nelson's driveway for their service workers to not only have side means of access to the property, but also as a parking lot. This is where they park their vehicles on Mr. Nelson's driveway. And now, because the trial court found that the statute of limitations ran in this case, Mr. Nelson has no claim, no form of relief that he can bring at all, because the town was found to be a necessary and indispensable party to his quiet title action. So here we have a forfeiture of property rights by Mr. Nelson, who is in possession of the property under a claim of ownership because a private party has disturbed his possession, not a disturbance by the town, not in reliance on any action by the town. In fact, Mr. Allen had begun disturbing Mr. Nelson's possession prior to any issuance of a permit by the town. So it cannot be said.
Counsel, we wouldn't be here but for your I don't know if it was you or who did this at the trial court. We wouldn't be here but for your dismissal of the town without prejudice. Is that correct? Because you filed your claim 2 days prior to the statute of limitations running, but in dismissing the town out, that re-triggered the statute of limitations, and then when you filed it back on August 19th of 2015, you were about 18 months late. But for the dismissal of the town, this issue wouldn't be before this court at this time. Is that right?
Your Honor, that's unclear because we don't know what the court would have decided on the motion to dismiss. It was never ruled on. However, that statute of limitations that originally applied to the declaratory relief claim. That was no longer in the case. That was also dismissed from the case. I do see that I have a little under 4 minutes. If the court has no further questions, I'd like to reserve my remaining time for rebuttal.
Thank you, counsel.
Thank you.
May it please the court, my name is Brian Imbornoni. I represent defendants, appellees, Scott and Catherine Allen. The court should affirm the dismissal order entered by Judge Kiley. The procedural history of this case is complicated, but the issue presented on appeal is not. Nelson concedes that the town of Paradise Valley is a necessary and indispensable party. So the only issue on appeal is whether Nelson's claim against the town is barred by the 1-year statute of limitations. The court below correctly found that Nelson's claim accrued by no later than February 20, 2014. Therefore, the limitation period expired before Nelson filed his motion to amend to add the town. That motion was properly denied by the trial court as futile. Nelson relies on the true quiet title exception to the statute of limitations addressed by this court in Cook and Rogers. That exception only applies to quiet title claims brought by plaintiffs in undisturbed possession under an existing title. And Nelson can't meet either of those requirements in this case. Nelson's possession was disturbed. I think I just heard Ms. Thomas agree that Nelson's possession was disturbed by the Allens. The complaint alleges that in 2008, the Allens' predecessors removed a tree and constructed a gate, which we just heard about. Nelson alleges that the Allens made unabated use of the roadway, used it as a service entrance to their home and to park vehicles, and that this, quote, impeded and impaired, unquote, his use and enjoyment of the property. The complaint goes on that the Allens paved a portion of the street with pavers, removed some landscaping, did other improvements involving relocating some fencing, and eventually obtained a permit from the town to complete the remainder of the paving.
And the basis for the claim of right to do all this is what?
After the permit was
No,
issued.
before the permit.
Before the
I
permit.
mean, I could apply for a permit to do some stuff on that land, too. I could use some extra tax-free land in Paradise Valley.
The tree was removed from a.
That can't be the only claim of right, is that a tree was removed. I mean, I'm trying to understand what your client's basis for seeking a permit and using this land is. Can you help me with that?
The Allen's basis for using the right-of-way is that it is a public roadway. The Allens made improvements to the public roadway. After Mr. Nelson complained, they obtained formal authority from the town to complete those improvements. But their right of use is no different than the right of use of any other member of the public that is entitled to use the roadway.
So your
as
clients
a
wouldn't object
right-of-way.
if any other member of the public just parked there at the service entrance?
Any other member of the public can use the roadway or park. The use isn't exclusive to the Allens.
So a group could apply for a festival permit on the land?
I suppose that they could.
Okay.
So the possession, the claimed right of possession was undoubtedly disturbed. The town's main response, Nelson's main response is that the town itself must disturb his possession. And Nelson never explains what this means and never cites any authority to support the argument. The town doesn't establish and maintain roads for the use of town officials and employees. Public use is the town's use of its public roads and right-of-ways. That use by the public is enough of a disturbance for the statute of limitations to accrue. And this conclusion is supported by the Cook decision. In Cook, the town of Pine Top Lakeside abandoned a roadway to Cook. His neighbor Heffel complained that it left his property deadlocked, and the abandonment was revoked. This court held that the statute of limitations did not accrue because because Cook, in that case, remained in undisturbed possession of the roadway. In paragraph 17 of the opinion, the court explained that there is no evidence in the record that Heffel or the town or anyone else besides Cook began using the disputed property. And the court elaborated in footnote 4 about the meaning of what it is to disturb possession. The court wrote that Cook asserts that no one infringed on his possession, and the footnote continues that the town did not challenge that Cook remained in peaceful possession and made no showing that Cook's possession has been invaded, disturbed, or infringed in any way. That is not the situation in our case.
Can you enlighten us as to Judge Swan's question about how does a government abandon property and basically give it to a private person?
Yes, this was briefed in response to the motion to dismiss by both the town and by Allen. A town has no inherent or common law authority. It can only proceed based upon its statutory authority. There were statutes in effect that have moved through different titles over the years. The abandonment would, by statute, cause the town can abandon property by.
Well, so it's like a government may. It seems to me maybe they abandon property because they no longer want to maintain it, be responsible for it. They decided it doesn't provide any particular benefit to the citizenry. I mean, I could see them doing that, but I'm just curious about how they abandon it to a private party. That part doesn't seem to make much sense.
That's exactly correct. But under the statutory procedure for abandonment, the roadway accrues to the benefit of the adjacent parcels. So,
do you have a cite for that statute?
Excuse me?
Do you have a cite for that statute?
I think It's 12508, but it is in a judicial code 3 or 4 compilations ago. The
Judicial code?
the statute in effect at the time that the town of Paradise Valley issued its resolution number 11 was 1962. The statutes have been recodified and renumbered various times. In the brief, we list a series of 4 statutes that.
Any material differences, though?
No, the actual a copy of the actual statutes from the 1962 version are included as an attachment to the Allen's motion to amend. Returning to the Cook decision, the reasoning of Cook is based upon the public policy for the true quiet title exception, and that policy is explained in the cases cited in Cook, including Mukhturian from California and Baumgartner from Utah. The cases recognize that the exception for undisturbed possession is based on the policy that without an infringement, the owner may not be on notice of the nature of his claim, and the cloud on title may never ripen into an actual infringement, so litigation may be unnecessary. Here we have more than a mere theoretical cloud that may or may not affect the undisturbed peaceful possession. Here we have a permit by the town allowing improvements and extensive improvements and use made by a neighbor and by other members of the public. Because Nelson's possession was infringed, the true quiet title exception doesn't apply, and Judge Anderson correctly denied the motion to amend as futile. Nelson's claim fails for a second independent reason. The exception to the statute for pure quiet title actions only applies to plaintiffs in undisturbed possession under an existing title. In this case, as the court has pointed out, Nelson does not claim the roadway under any existing title. Therefore, his claim also fails under the Rogers decision. Now, going back to the allegations of the complaint, in 1956, the Beamans deeded the road to Maricopa County before the town was incorporated, and then deeded the north portion to the McMahons, actually the Beamans' daughter and son-in-law. Nelson claims that in 1962, the town abandoned the roadway, but that's disputed. But even if that was accepted, the problem remains that when the McMahons sold the property in 1988, the deed excluded the east 25 feet, which includes the roadway. And there's a long chain of title from the McMahons to Nelson, and each and every deed in the chain excludes the east 25 feet. So to prevail on his claim, Nelson has to first prove that there was an abandonment to the McMahons, but then he has to prove that the ownership of the roadway was acquired from the McMahons by a predecessor in interest through adverse possession, which is a very, very tough claim to make. These facts bring us under the holding in Rogers. In Rogers, the plaintiff was suing to quiet title to an easement across the U of A farm by Maricopa. The court held that the true quiet title exception could not apply because there was no existing title. Relying on the Hupiana case from Utah, this court held that where the plaintiff's claim to quiet title requires proving some underlying claim first, the exception, the true quiet title exception, does not apply. In this case, the title to the road is held by the town according to the town's books, according to the county records. At best, for Nelson, it was abandoned to McMahon, but Nelson still has to prove that it somehow came from McMahon over to Nelson. So this is the same situation as Rogers, where the plaintiff had to first prove prescriptive easement.
I'm sorry to ask such a simple question this late into the game, but who owns this property?
The town of Paradise Valley's records, its maps and books show that it owns the property. The county assessor is not taxing this as private property.
So
the
it's
county
your client's,
treats this.
it's your client's position then that this is public property,
Absolutely, yes, Your Honor.
and that the town owns it despite its purported abandonment.
Absolutely correct.
Okay.
And that's the town's position in the pleadings that it filed in the case before being voluntarily dismissed. Nelson conceded that Rogers applies. In his original complaint, he included a declaratory judgment claim, and in the response to the town's motion to dismiss, conceded that the quiet title claim, his quiet title claim, was contingent on his declaratory judgment claim, just like in Rogers. Now, when Nelson dismissed the town, he also filed a notice of dismissal of the deck action against the Allens, but that doesn't change the underlying nature. If you look at Rogers, which relies heavily on the Hupiana Trust case from Utah, Hupiana Trust says that the court should be cautious about plaintiffs avoiding the statute by dressing up their claims as quiet title claims when there really is some other underlying claim that is barred by the statute. Here, Nelson has several steps to make before he can establish title to try to quiet it, and that's, under Rogers, a second independent reason to take him out of the exception to the true quiet title, out of the true quiet title exception. I'd like to briefly respond to some of the arguments by plaintiff in the briefs. Nelson argues that mere notice is not enough for a claim to accrue under Cook. That may be true, but we have much more than notice of a mere theoretical cloud on title. Here we have an actual infringement or disturbance. Our client's view, these were all improvements. Nelson's view may be different, but here we have more than a theoretical cloud on title, which may or may not cause infringement or disturbance in the future. Nelson argues that issuing a permit is not enough, arguing from condemnation cases. Those cases hold that compensation is not required unless there's been a physical taking. Well, here we don't simply have a permit. The contractor acted on the permit, and there was physical activity. A few comments on the amicus brief. The town makes several important points. A town can only act through its officers, employees, and agents. The theory that the town itself must disturb Nelson's possession is not a meaningful concept. Approving the right-of-way permit and the actions taken by Allen and his contractors in reliance on the permit are actions attributable to the town, and so is the public use. We all agree that the town of Paradise Valley is a necessary and indispensable party. Because Nelson's claim against the town is barred by the statute of limitations, Nelson's claim against the Allens was properly dismissed. Therefore, the court should affirm the order of dismissal. And for the first time in my career, I have time left over. Thank you.
Thank you.
Thank you, counsel.
Thank you, Your Honors. First, Rogers is distinguishable. As the Rogers court held, the statute of limitations defense turns on whether or not the plaintiff asserts a possessory interest. Rogers did not, there was actually Shug's. Shug did not assert a possessory interest. he asserted a non-possessory interest, an easement interest, and there the Board of Regents had taken steps to physically appropriate the land in question, the road in question. They had blocked Shug's access to the property.
But here your client is claiming not only a possessory interest, but title.
That is correct. That's the reason for his
Client
quiet.
can sell this land.
After he is successful in his quiet title claim.
But his position is that he should be able to sell this land.
That is correct, Your Honor.
Okay. Mr. Imranoni mentioned an abandonment statute. I have failed to find one.
Your Honor, I believe the statute in question actually refers to a vacature of property.
Okay.
And I believe there's a distinction between vacating property and abandoning property. I think the reason that we can't find such a statute is because no such statute exists. So the answer to your question of how does one abandon property? By a resolution. And we see that the
But
town...
what does that mean? Is that abandonment in gross? You just pick a person and abandon property to them?
Your Honor, I believe we look at who has requested the abandonment, and then it's abandoned to that particular party that has requested the abandonment.
But that wasn't anywhere in the language I could find in the resolution to the town.
And you're right, Your Honor, it wasn't. And if the record is more fully developed, we would actually see that the petitioner who requested the abandonment was Mr. Nelson's predecessor.
But you would agree
in
that's
interest.
not in the record before this court at this time?
I would agree, but if we look at Cook, the Cook court, again, we're dealing with a resolution there. So we have a similar situation, but as I mentioned previously, we do not have the additional step here of the town taking that action to rescind
But
the
wouldn't that be
abandonment.
unconstitutional? I mean, if the government just starts giving people land to sell, I mean, do you get that deal? Because I don't.
Your Honor, the government would not just be giving people land to sell.
But isn't that what your client's position is essentially based upon, is that the government decided it didn't want this land anymore, so it gave it in a marketable title to your client's predecessor in interest?
No, and that's where this case is further distinguishable from Cook and actually presents an even stronger case for Mr. Nelson. In Cook, the road had originally been a public right-of-way. Then the town of Pinetop Lakeside abandoned it to Mr. Cook. Let's put aside for just a moment this question of what exactly an abandonment is and who it's abandoned to. And then then the town purported to rescind that abandonment. Here, this parcel of property was originally owned by the Beamans. They subdivided their property. For some reason, they thought that the best way to give the back property access to the main roadway would be to quit claim the deed to the county. Why they did that, I don't know. But that should not have been the way that they handled this. But the town later recognized, when the McMahons went to the town and said, hey, will you abandon this property to us? It should be our driveway. And they said, yes. They passed the resolution saying that the property had never been and would never be used as a
But then there's
right-of-way.
another thing that should have been done differently, right? They should have gone to the town and said, look, this quitclaim was a mistake. How about we buy it for you for $1, and you quitclaim it back to us? That would have been a lot cleaner, right?
Your Honor, I see my time is up. May I answer the question?
Yeah.
Your Honor, I don't think that the McMahons were required to do that. They went to the town. If the town wanted to sell it, they could have done that. They chose to abandon the property. I don't know why that should be to Mr. Nelson's detriment.
But I've been dealing with property cases for several decades now. This is the first time I've ever heard of abandonment as a means of conveyance. I mean, it is a little unusual. Quitclaims all the time. But abandonment conveying marketable title is a new concept for me. Is there any case or any statute that you can cite that stands for the proposition that the government can abandon marketable title rather than deeding?
The cases that I would cite to are cases that simply recognize abandonments. The court, there's many cases, and again, Cook, that in the facts we see that there has been an abandonment of property. However, if the court is hung up on this issue, I would just remind the court that The merits don't have to be decided here. This is simply a statute of limitations
I understand. I wouldn't say hung up, just curious. And so I appreciate your time.
Thank you.
Thank you, counsel. We'll take the matter under advisement. We'll issue our decision in due course. We'll be at recess.